Yesterday, harassment in the township. This was not a discussion of how to commit wage theft or how to commit harassment, but instead, how are we going to comply with the laws that we have? So I'm not going to talk for an hour on wage theft. For those of you concerned, that would be cruel and unusual. It shouldn't take us that long. Okay, so we'll touch on that. And then I'm hoping we'll have time. The original plan was to do this with an abbreviated harassment discussion because that was in the supervisor's room yesterday. I know a lot of you maybe didn't see that, but it's just as important for you as it was for them. So, okay, wage theft. The law changed. This isn't new news anymore. This is, somewhat old for a lot of you. You've heard about this, you know about it and understand it. This was going to be one of the presentations we did on the short courses just before the pandemic. We were packed up, ready to go, and then got canceled. So, but this thing has existed for a long time, but there were new changes made to it in 2019. The purpose of all this was to protect wage earners, okay? People typically not in management or in disadvantaged positions, the young, people who are immigrants, people who are English as a second language, disabled, or they have other hurdles that maybe prevent them from being as aggressive in getting the wages that they were promised or that they're owed. And this was a real problem in some places, okay? So much so that legislature at that time was bipartisan. Shall we say, this is a bipartisan bill. The chambers were split in their leadership, I believe, as was the governor's office. So this was something that, it's surprising in these times that they got something done. It means they really saw a need. So it aims at employers. And you may be asking yourselves, well, we're the clerks and treasurers. We're not the employers, which is true. But often you end up doing the paperwork. And because you often end up doing the paperwork, I'm talking to you about it. Okay. It might be something you get asked to do. Strictly speaking, you may not have to. If you're an elected clerk, elected treasurer, you have some control about what you do. And this is not necessarily a statutory duty. That's not to say don't do it. It's work with your supervisors, though. And hopefully they understand what's your job and what's extra and that you're helping them. Okay. So this law says employers, if you're not paying what you're supposed to, there are going to be penalties against you. And this bill broadened the penalties and the law enforcement options. It let the attorney general, for example, start pursuing some of these problems directly rather than county attorneys. So overall, the legislators are saying this. Everyone is entitled to know what they will earn, what is going to be deducted on a paycheck, and a clear earnings statement that has all of the benefits and all of the limitations put into it, and that it's going to be paid in a timely way. The timeliness of the payment has caused problems for some townships. Okay, we'll get to that. So, a summary of the duties. At the beginning of new employment, or whenever the conditions of employment change, you're going to have to provide a form. And there's a sample form already produced by the state's Department of Labor. Just use this form, and we will link it or put it up with the slides on this online. And so you can have it. And it's a form you just need to keep locally. Okay. I mean, if you have good internet, you could download it each time. You are going to use this form if you have employees. Okay. Because at the start of employment, and anytime you change any benefit, so the wage goes up, the vacation goes up, you're going to deduct more or less from their deductions on a paycheck, something like that. This form has to be redone and given to the employee. You also have to keep on hand a copy of this record. This is something that the clerk would keep as a matter of record keeping duty, okay, in the employment files that you have. So, a person would arguably get several of these over the course of normal employment as things change in their employment. Okay. In addition, you have to give all of the policies that you have. If you have an employee handbook of some kind, or even if they're just passed as resolutions and they relate to conditions of employment, you have to provide all those to the employee. For folks that have this set up as a policy book and everything's in one place, you're probably in a little easier situation. You can just provide it to them. For those that didn't do that, which is common for a township because we just don't have so many employees that we need a book and formalize and all that, they meaning the board, probably created rules and restrictions or empowerments for employees doing those jobs through either motions at the board meeting or through resolutions. The wise practice here would be to go look for these things, collect them, and provide them either as is, if you don't want to create a new document, or some kind of summary document stating here's conditions of employment or policies of employment that relate to you, employee, and then give that to the employee as kind of a placeholder employment handbook. For the sake of efficiency, if you collect these things or you make the summary page, make sure the supervisors review it, in a meeting, okay, in a normal, regular, special meeting, that they review it before it's given to the employees, because maybe they don't even realize what was in those resolutions or motions. We tend to deal with the right now and what we think is the near future, and we deal less so with, well, what did they do a long time ago? They may not even know what the policies were. So before you hand them out, check with the supervisors on, are these still correct? Do you want to make changes? Do you want to wipe all of these out and just undo all these and say we're starting fresh with something else? Okay. But we give all those policies to the employee and keep a copy of what you gave on hand and on file and easily accessible. Okay. Because if you get inquiries about this from a law enforcement official or AG's office, you're going to want to be able to, yep, here it is, pull it out and make sure you've got it. Okay. And there's a list of things that have to be on the wage statements, the earning statements, okay, your pay stub. There's things that must be there. And again, this is in reaction to employers who didn't do things right, and it caused problems for employees. So yes, we're all paying the costs of bad employers here. Maybe there were 5% of employers were bad, but everybody's having to deal with it. Okay, last, and the struggle is pay wages in full and on time. On time is going to be more frequent than some townships would like. But when it comes to employees, it has to be done basically once every 31 days. Okay, we'll talk more about that as we come along to it here. So here's the changes to the existing law. Give me one moment, please. I have my traditional short course cold right now. So I said before, the wage theft law had existed before 2019, but there were things that they added to it. And these are the things that were added. Okay, so the highlighted parts. Okay, these are the things that they added. And I just mentioned these, the notices, the payment stubs, and the record keeping. We just touched on that. But the things that were already there before that you may not have been aware of. No retaliation. You can't take adverse employment reactions against somebody for them trying to get paid what they're owed, or for them inquiring about what they're owed, or getting a benefit. There were already provisions moving contractors off into a different place. They're not covered here as contractors. Okay. They're still owed their money, but it's by virtue of contract, and a contractor isn't employed by you in the same way as a true employee. So contractors are considered to be in a different position. Okay. There's the enforcement. There was enforcement, but it was just not very convenient or wasn't being used. There were criminal penalties. Again, they weren't being used. And what we've learned in the couple years, 3 years now since this thing passed, is that the Attorney General's office, in particular, has used the new powers to try and go after employers that they learn are problematic. And so they are taking steps on this thing. This thing is being used. And it's typically higher profile folks. It's not typically a township or something like that. It doesn't mean you can't pay attention to it or that you're overlooked. It just means you're in a better position than if you were this big employer and there's a lot of people who complain about your practices. Okay, so going back to that start of employment notice and change notice, here are the more in-depth pieces of this. Again, this stuff is all on the sample form. So you don't have to remember this. You just have to remember to get the form and fill it out. But here's what you're going to see, and here's what you're going to have to put in there. Okay, we'll go through it. There's the sample notice, all new employees, all existing employees with a change of circumstance, right? Anything new. And you're going to have to get the signature of the employee to document that, yes, indeed, they received it, even if they lost their copy later. You sign, get their signed copy it, and you keep that on file. Okay. The description is going to give their rate of pay, and that can be listed. Obviously, it could be hourly. It could be listed as a daily rate or weekly rate. For people who are true salary, which is very rare in a township. Okay, true salary is very rare because people, when they say salary, they usually mean, oh, that person can't get overtime pay. And there's not a lot of opportunities for a position like that in townships as they exist because they're just so small. There's required to pay somebody a minimum of $684 a week, I believe, and they have to fit it within certain categories to be exempt from the overtime, which is the FLSA, the Fair Labor Standards Act. So because of that, your township employees should fall into that hourly, daily, or it could be a weekly rate, but it still has to somehow translate into at least minimum wage. And if they do more hours than the 40 per week, you'd still owe them overtime. Okay. If they are salaried, you put that down. If they're shifted, it just provides for a bunch of different options. Okay. You may be thinking about contractors here. Many of you have contractors. Again, this isn't for contractors. So you're not going to give this form to your contract snowplow operator, your contract work crews, or something like that. You have to specify the pay period. At a minimum, you have to pay once a month. There's no way around that. There is no exception. Most employers these days pay either weekly or every 15 days or every 2 weeks. 26 pay periods, for example, we take the year and divide by 2, 26 pay periods. That's the common way to do it. Now that means the employee has to report their time. If the employee doesn't report their time, you can't pay them. That I don't consider to be an exception. Okay, that's just the employee isn't doing what they should, and that has a different problem, a different effect. You may not be able to pay them on time, but it's not because you chose not to. So, and I know the question is going to be, well, gosh, we only have one meeting a month, or for some of you even less. How do we pay once a month? And we can do that. There's a way to allow us to do that. I'll get to in the next slide for you. Allowances have to be on there. So this is anything that they get as a benefit. If they get meals during work times, if they get any side benefit. Lodging is really unusual, unlikely to see unless you're sending them somewhere for some training, maybe something like that. But we just don't see it a lot in a township. And then any other compensation. So just think broadly. If there's anything at all that they can get, anything that is reimbursable, that gets put on this form as much as you can. And if more things get added later, you change the form and you add it. Or if the board takes something away, you change that. If they're allowed mileage for something, well, the mileage should be on there, right? So it's anything and everything you can think of here that they may get as an allowance. Some pay beyond their base rate that we mentioned in the second primary bullet point here. Vacation time, if they get that, that's put on there. Excuse me. The deductions. So you should list what are the deductions that a person's going to see on their paycheck, and some of them are the common deductions. If they're para eligible, you'll see that, and it's all those things. If they're subject to withholding, the most common one probably being garnishment for not paying debts or for family law related matters, child support related matters. Those you'll see garnishments, and you may not know right away. Those may come in later after employment. And if that's the case, you're going to have to give a new change form, adding what deductions are going to be added to their paycheck. And then you have to provide your own information, the township's information, to say, not your personal information. The township's information, the employer name, township of or township, Belgrade Township, what have you, the address, the phone number. Um, Basically, where can somebody be reached? And this should be, think in mind of law enforcement. If they're going to call somebody, make it easy to get to someone. Okay, don't make it difficult for them because it's only going to make them upset. Um, Make it easy for them to contact you. I'm going to look here over to the chat for just a sec. You are friendly, yes, yes. Chatty, supervisors are friendly and chatty too. Okay, employees, does that include the board? No. Elected officials are not employees. So you don't need this for them. It's not a bad idea to do it. It's fine to do it. Okay, but they are not included in the law for this. There's certain things that are excluded. The form is on the it's Department of Labor or DEED, Department of Economic Development, it might be, or Department of Labor, but we're going to link it or put it right on the webpage for you folks with this kind of as a packet. Somebody says they pay quarterly. Again, if these are all elected, supervisor, clerk, and treasurer, all elected, they can be paid quarterly if you want. The fact that it's been quarterly a long time doesn't really mean anything. It just means that's comfortable. If you have let's say you have an appointed clerk, appointed treasurer, as in never elected anymore, option B, they're employees. They must get paid at least once a month. I thought we were told no, it's agreed to by the board in writing. I think that's about quarterly pay, and it's kind of off the table. The board as elected officials isn't subject to this, so they can just set their elected officer pay structure as they want. We do recommend more frequent as opposed to less frequent. Do election judges count as employees? Yes, they do. Good question. And I know there's a lot of groans there right now. Okay. A deputy clerk. Yeah, deputies are also employees. They're not elected officials. All right. Let me come back to election judges. We might have to take back the groan, but I just don't remember. I think we'll get to it on a slide shortly. All right. So wage payment. So that payment of base wages. Okay, on time means at least once every 31 days. The way to do this without a board meeting is very simple, and it's designed so that you don't have to have board meetings to do this. The idea is, if a person is an employee and we know their rate of pay, their allowances, their paid time off or vacation or sick time, whatever it is, we know that in advance. And the board of supervisors sets those things. So they know what they are. And they also set for example, this person can work up to 20 hours a week. That person can work 10 hours a week. This person is allowed to work however long it takes to get the job done, including overtime. They set that, or they should be setting that. Because we know that in advance, it's already set up in this statute 471.38 that for employees in paying payroll, those employees can report their wages, and then an authorized person or persons can just pay the wages. So supervisors, if we happen to have supervisors in the room, and those who are going to be skeptical of this, they can look at the statute. You can have them call me or Carl. That's just fine. Okay. And we'll give them the same answers I'm giving right now, or send them to this video. Okay. For payment of wages, we know what they should be in advance. Therefore, the legislature has given this payroll exception to ensure that employees are paid regularly and on time, and there's no hurdle, an artificial hurdle of a board meeting or something like that in order to get them paid. This is not like the normal claim process. So please, if you have employees, use this process. We recommend that you pay at least twice a month. Okay, every 2 weeks, 2 weeks is fine too. It's roughly that, but that gets you the 26 pay periods. The reason we try to avoid once every 31 days is if you miss a meeting, there's a potential that it could get screwed up and now you violated the law. Whereas if you plan to pay every 2 weeks or twice a month, there shouldn't be any time in which a person hasn't received a paycheck, in over 31 days. You really kind of guard against that by setting more than one pay period per month. So that is the best practice recommendation. Yes, it takes more work. I do understand that. Keep in mind, it does not have to be clerk or treasurer work. There's nothing in statute saying you must do that work. Treasurer, you got to pay out things when they're directed. So there's that aspect of it. But actually processing payroll, that could be done internally, could be done by a supervisor, could be done by an outside party. Those of you who are able and interested, you can do that. You should be, fairly compensated for it. It should be added to what you do as an officer and recognized as this thing that has to be done. If you have enough employees, I guess an employee could do it. Nothing prohibiting that. As a best practice, though, no one should review and approve their own paycheck. That's the risk. That's the issue there. Oh, the 3 signature rule. Ignore the 3 signature rule. Oh, ignore that thing. Okay. I'm not entirely convinced that 3 signatures are required on a check, because there's a statute on this, and there's a way that I look at it that says a document signed by 3 people, the chair or supervisor, the clerk, and the treasurer, becomes a check. I don't think it says that a check has to be signed by 3. Now, the banks don't care at all. It has nothing to do with, they don't care how many signatures are on a check. They don't even look. That's not something they engage in. So these payroll exceptions, I mean it, I know. And this is the thing, people are fighting against us. Well, what about this? What about this? No, you have a payroll exception. Stop signing with 3 signatures on payroll checks. Counties and cities, they don't have every county commissioner sign payroll checks and every city council member sign these things. That's not how this happens. Payroll is different. It's not a claim in the same way as the 3 signature idea that folks are used to. Okay. And keep in mind, over the course of the pandemic, we've been telling townships, if it's inconvenient or it doesn't work to have people get together to sign with 3 signatures, stop. Don't do it. You are not going to get in trouble for that. It's just fine. The banks will see 1 signature if they even look for a signature and pay the thing out. Okay. 2-week pay period form that for the treasurer and clerk. Again, if they're elected, it doesn't have to be. If they're appointed, yes. If they're appointed and they're never elected anymore, they are employees. They have to be paid at least once every 31 days. If the employee doesn't submit their hours regularly, that's the real employment problem, and they're not following a policy, and there should be discipline imposed. It would be something to try and take corrective action so that the employee's time is reported and that there's no chance that you're going to miss something. But we have a copy. The slides will be online. I'll put the slides online. Yeah, banks, Anita just mentioned, the banks sometimes they don't even like multiple signatures. That confuses them, I guess. No disrespect to bankers out there. Okay, it's just that's not the normal course of things, and people don't pay attention to it. Okay. Who is an employee? All right, there we go. This is where we came back to our election judge thing. Everyone except elected officials, volunteers, and contractors. Those are the folks that we're going to exclude. So it's easier to think of this in terms of that exclusion. If elected, then they are not subject to this whole thing. Folks get confused about, well, what about we have a clerk who is, they were an interim appointment because the old clerk resigned, and so we have a new clerk, but that person was not elected into office. That doesn't matter. What matters is the nature of the office. So a person who's appointed into an elected office is still deemed an elected official. So it's like, what is the suit that official wears? Is it the elected suit, meaning at some point it is up for election or not? And so if that official is in an elected slot, that seat is elected at some point, no matter how they entered. That's an elected position, not subject to this. Volunteers, we don't pay at all. If you're paying a volunteer, they're not a real volunteer, and then yes, you have to do this because that's not a real volunteer. Contractors, likewise, a contractor isn't an employee. They are self-employed or employed by a third party contracting with you to do work. Okay. The safe option is intended to avoid civil and criminal penalties. So that's why we take the very broad view of this. I have, at least for now, these are employees. Okay. Election judges. So yeah, we're going to include them. They get a wage statement like this at the beginning, and chances are you're just going to give it to them every year unless something has changed. Hourly or salaried, appointed, meaning always appointed, never elected. Okay, clerks and treasurers. There's also a provision in there that if employee is not eligible for para, they're an employee for this. Okay. So safe answer, just do this because it doesn't hurt to do the thing, even if you didn't have to. Okay. Bank requires it or they won't deposit it. That's, oh, I'm sorry, that was NEAS 1. Okay. No, it's, again, folks, throw out that idea of the 3 signature thing. It's confusing, it's misleading. It's not that you have to stop the practice, but we're in the employee box right now. That's all we're looking at. Okay, put the blinders on for everything else. Claims from contractors, claims from everybody else. Apply your 3 signature rule if you want. Okay, but in this box that we have here on employees, stop with the 3 signatures. You don't need it. You could do it if you want, but it's just a hassle, and it's going to cause you more board meetings or more communication, more having to drive checks around and all this stuff. You don't have to do that. Okay. Clerk is also the town hall manager and manages rentals. Are they an employee? Arguably not. That could be made a part of their duties as it's administrative in character. I think you're safe if it's that. Now, if the clerk is out operating the plow, I think we got a different issue. If it's manual labor or things that you'd usually go outside to do, then we probably should do one of these. Okay. If the supervisor does work for the township, are they considered an employee? We're probably talking manual labor again, not managerial or administrative. In that case, yeah, let's treat him as an employee for that part of it, just like we do with the conflict of interest waivers. We think, okay, that seems extra work. It's not within their elected duties. So we treat them as an employee for that. Our bank will not cash deposit without 3 signatures. I don't know why they would do that unless they've been told, well, we have to have this on there. I would get that changed with the bank in particular for the wage issue. What about elected official not eligible for para due to being retired and receiving their para? Remember, elected official completely out of this. Don't even have to consider para. Okay. So don't worry about that. I see there's some others in the Q&A. Okay, overtime. Minnesota law has a different overtime law than the federal government. Minnesota says 48 hours and over is overtime. Just use the federal. It's 40 hours. It's basically a preemption thing. New employee report. Does that include elected official? Nope, not elected officials. We'll put the notice up online for folks so that they can get that. If Lori or Kristen could search for the Minnesota wage theft document and put a link to it, folks look like they would like it today. Trainings belong under payroll in our taxable. It's a matter of if they get paid. If a person gets paid, then yes, and they're an employee, then you would withhold, you'd pay them for their time and you would withhold for that. Allowances are not regular part of pay. Can these be separate and not part of salary? Yeah, so you'd want to separate the allowances. The allowances are listed separately as the bonus, not bonus things, but things beyond the base wage that they get. And that's why you put that separately into the wage theft notice. I mean, on the paycheck, they'd still appear the same. You'd still show them in that same way. Or on the claim where they turn in, like if they give an expense report for mileage and whatever they had, that still goes in and it's reflected into the paycheck. Are weekends included? Yep, 31 days strictly defined. 31 days. You get no more than 31. Election judges, yep, give these to election judges. Okay to get appointed positions 1099. No, we're not touching tax today. No, we'll touch that in a different setting. Election judges. If we treat an elected officer as an employee, do we have to give 2 paychecks? No, it doesn't have to be 2 paychecks. It can just be separate line items of how they earned that money. And you'd reflect that into the wage theft document, and then it would just be added up into the paycheck. All right. And Gretchen did put, I thank you, Gretchen, the link is in the chat, not the Q&A, but the chat. So there's a employee notice form there. And again, we'll have that up for folks. If you don't want to go now, that's perfectly fine. Okay, record keeping. So you, as the clerk, the treasurer, here's your duty. Here's the part that you do need to ensure once you receive, you have it on file and it's available. The name, address, occupation of every employee, their rates of pay, which, if you have it on these forms, you're fine. These forms will take care of that, okay? Hours worked each day and week. So that's what the employees are going to turn into you. And that's important for this, but it's also important for outside the wage theft document. It's important for how much do they get paid and ensure that you are paying them properly. Because if they do overtime pay and you don't pay them, that's a big problem in and of itself, related to wage theft, but it's its own claim too. A list of employment policies. So this is where you categorize them, unless you just have one place and then it's a reference to that, or a copy of the book, and that's fine. And then copies of all the new hire and change notices. And this doesn't have to be in one place. This could be per employee file. That's probably the better way to approach it. So that if somebody wants to see a certain employee's file, they're not also happen to look at other employees' information that aren't necessary at that time. And we have a 3-year retention period for this. You're not going to get harmed for holding them longer. So and you may need to hold them longer. It occurs to me now that the government data retention schedule may provide a longer retention for this. And if so, we would want to keep them even longer. But the wage theft law itself has a 3-year retention period. So here's the fines: $1,000 fine for each failure to maintain one of these records. So it could add up quickly, right? There, when I say they are enforcing, I'm serious. They really will and really are. And then if it's a repeated problem, if they have to come back several times, you don't fix it, then it's a $5,000 fine. And these should be fines, I believe, against the township, not against individuals. It's the employer. On the earnings statements, remember one of the requirements is that people get an earnings statement itself. One moment. No. Anybody appointed to a commission, I think you would treat them as an employee in that situation because they're not elected. So we're going to treat them like an employee for whatever they get paid for. Okay. If we can touch on clerk treasurer duties at the end, we'll try to touch on that. But I don't want to do it now. Employee policies for election judges. Yes, Kathleen, you should, because election judges are employees. They get paid as employees. They don't get 1099s. They give them W-2s, and you treat them that way. So don't try to treat them as something separate just because they're in the election context or they're used for a day a year. Okay, earnings statement. That earnings statement should include employee name, rate of pay, allowances, hours worked. Chapter 177 is the state's wage and hour laws. For you, I don't anticipate, again, the towns are going to have people exempt from wage and hour laws. So you're probably not going to have to worry about the exemption there. Gross pay for that period. So the top line, what did they earn? Their hourly rate times, the hours worked, and what is it? The deductions that they have, which most people are familiar with seeing. The net, so what are they taking home? These are all things that your paycheck probably already provides. And if you're using software to do it, the software companies are aware of these things and by now should have already built them into it if they weren't there already. Okay. Pay period end date, so it's from when to when. And then, of course, your contact information again. Okay, so here's the penalties that we've got. The employer civil penalty, I touched on this earlier, $5,000 against the employer for repeated violations. And I don't know how strict they're being. So is it a violation of you didn't keep this, your name and address wasn't on it, so that's $5,000. And then it didn't have an extra deduction, and then it didn't have an allowance description in the wage theft notice form. And so now we're up to 15,000. I don't know how specifically they're looking at it, but I think they could argue for more rather than less. Here's the other part. There is a crime attached to this. So the additional criminal penalties here are listed. And this is the part that really they want to make clear they're focusing on it, make clear that they're approaching this kind of open-eyed and that they're trying to comply with all of these things. And if they're trying to comply, there should not be a risk of a crime, because crimes have an intent element usually. So if we're trying to do these things, the AG and prosecutors aren't out there to just hammer a township and the supervisors. It's folks who are doing something kind of egregious, and they're really being reckless or not caring about how their employees are treated at all. So here's the criminal part of this. So if a person fails to pay all the wages at the rate agreed or required, which is probably reflected in that form, if there's directly or indirectly causes any employee to file, I'm sorry, that's 5, says file a receipt for wages greater than amount actually paid to the employee. Okay. This is where they're supposed to get more and they didn't, so shorting them basically. Okay. Or if the employer goes back and says, you owe us money back, we overpaid you, you can't just go get the money back from them. That was also a problem, and it's something that this law stops. So this is one that we have received in our office. Well, we overpaid them. Can we just ask them to give it back? No, you can't. For that, you're probably going to end up working with your township attorney. It may be that it just gets credited against future earnings, but it may be that you stop and work with the attorney and you inquire with the AG or somebody about, hey, how would you like us to remedy this so that we don't violate the law? Here's our accounting. Here's what we understand to be true. They'll probably, if the AG gets involved, they'll probably talk to the employee and try to learn, okay, are these things true? Is this the rate? Is this what you worked? Is this the allowances? And try to see if there's agreement on the facts. And if there is, should be easy to remedy then, either by rebate, refund, or by crediting against future earnings. Or if you try to fake, this is fraud. If you try to make it look like you paid wages that weren't actually paid. The criminal penalties up to 20 years. This is a big deal. Okay, we're in felony world here. A fine of not more than 100,000 or both if the value of the wages stolen is more than 35,000. Now, since so many townships don't have employees, and even those that do, they're not full-time, many aren't going to be subject to these kind of penalties because folks don't make enough money to reach these thresholds in a township. Okay, so it depends on how much was stolen. This is the sliding scale, okay? And I won't go through every one of these here. But it's at the most this 20 years. So you peg where your employees are. What do they get paid? What could they have withheld from them? And it's over a period of 6 months. That's how we aggregate and figure out what this is. That could be the penalty, not on you. It shouldn't be on the clerk or on the treasurer. The buck stops with the supervisors. It's really their job to ensure that these things are done. Okay, I just know that they're going to use clerks and treasurers to help do it. Okay. Planning, okay, complete the I-9 form. Yes, if they're an employee, you're gonna have to do all the stuff for employment. Withhold taxes for election judges. I believe you do. There's a couple ways to do it, but I believe the clean way, and then it makes it easier for your election judges, is to do it and withhold the taxes, okay? What was the 2019 law? The 2019 law was the one that just had fewer penalties and fewer restrictions in it. So it existed, but it was just a little bit less restrictive on employers. So these fines are implied only if the employer reports find them. Well, there'd have to be a finding of some kind of wrongdoing. So if you're doing everything right and there's a report and it comes back, they can investigate and see you had the file and see how you documented everything. There shouldn't be fines or criminal penalties in that case. Okay. If your board meets monthly, you pay employees every month. Are we breaking the law when meetings are more than 31 days apart? Yes. Pat, you have to do this. They have to get paid at least every 31 days. And this is one of those pieces that we know townships don't like. Stop trying to put payroll through the board. That's really the answer. They have to be done. It could be a supervisor that receives the pay statements and approves them. It could be the clerk or treasurer who receives them and approves them. All of that is fine. Okay. There's many ways to accommodate this, but it must be accommodated. And yes, your board's going to have to make changes. And it doesn't matter if they like it, because you're looking at a slide that imposes criminal penalties. And saying, well, we don't meet every month is not going to save anyone at all, because you're not supposed to wait till a board meeting to pay employees. That's what that statute I mentioned earlier was. It's saying you have this exception. It doesn't have to go before the board for payroll. Payroll has to be paid. And here's your opportunity to do that in a summary way without a board meeting. Okay. You guys jump on election judge stuff, don't you? Yeah, go back and do notices and put them in. It's better to show, oh, we didn't know this and we're trying to do it, and here's what it will be as you work for as an election judge for us. Okay. Lauren, you can still do a W-2 for less. The problem is if you pay them without a W-2, they have to withhold or they have to remit taxes. So frankly, from a judge standpoint, it's probably better for the township to just do it this way, the way they one method for all employees. Don't make distinctions based on the job function. And that's outside the salary basis, right? Salaried is a different deal. They're still paid W-2 though. Right, Randy. So election judges are employees, so they fall within that category of just approving payroll, because the board sets their rate of pay and should understand, well, they have to be there for the duration of the election and all the stuff they do with the election. And they have so much history about what they do, we kind of have some idea of what it's going to cost. Why would a board not meet every month? In some places, the boards meet less than once a month. It's something that we struggle against and that we try to inform them they really should be meeting more than that. But some places just don't do it. So there are some problems with that, but it's not something we can solve. Let's see. Yeah, so every employee gets this earnings statement or the change form whenever something changes for them. The new hire document, that's the thing that that Gretchen kindly put into the chat box. I'll copy and paste and should show up at the bottom of the chat. And I click everyone. Okay, so that should show up for everybody. That's the thing that you're going to need and you're going to use over and over. If you want, fill in the parts that don't change, like your address and contact information, make your copies and then do it that way, so you have less to fill in each time if you're doing it by hand. It's PDF, and if you have editable PDF software, you can make this even easier for yourself. Okay. On the never withheld taxes, folks, if they haven't been withholding taxes, you need to call our office. I'm not going to say more now. Okay. Let's see. Okay. Screen sharing has stopped and the window is closed. I'm not sure. Kristen, did you stop my screen share?
I might have bumped something, sorry.
Okay. It might have been me, actually. It disappeared, so it could be that it wasn't working. So, okay. All right. So I have a bonus slide. Okay, the bonus slide. I touched on this earlier, but it's about salaried basis.
I can't see it. It's not up.
Let me try again. Got to adjust windows here, sorry. Okay, how about now?
Yep.
Okay, thank you. Okay, the bonus slide. This is about salary basis because so many towns At least I get reports of this. I imagine Carl does too, saying, "Well, we pay the person on a salary basis." Well, if it's elected official, it's fine because there's not a minimum wage requirement. But if they're appointed clerk or treasurer, or they're an employee, then there's restrictions on salary. Okay. You could say a person is salaried, but it still has to ensure that they don't do enough hours to make their pay less than a minimum wage, because there's still a minimum wage requirement for them. And if they work over 40 hours, they would still be owed overtime pay at whatever the rate is for that. So beware of salary. The true salary is only available if first they make a minimum amount per week, 684, I believe it was, or 687. Okay. That level of pay takes out a lot of townships employees or appointed clerks or treasurers. Okay. It just does. Even if you were paying that amount, there's a duties test in which the employer has to go through and decide, well, does this person fit one of the exemptions to the Fair Labor Standard Act? So some of those are, like example, a chief executive. Well, chief executive, there's an exemption for that in the Fair Labor Standards Act. There's one for what's called learned professionals, meaning lawyers, doctors, engineers, architects, things like this. So if you have that, you'd be able to make them exempt, but towns don't generally employ those folks directly. We do that by contracting or just kind of retail, contacting someone who's in a different organization. There's creative professionals, people, these are artists. They can be on salary. There's a few others. Okay. There's an administrative exception. That might be the only one that could fit for a township that I can think of. So true salary probably isn't going to work for townships. They're probably going to end up having to pay overtime and at least minimum wage, and be certain that if they're paying a flat wage, that's really the correct term. If they're trying to pay a flat wage, they still have to meet minimum wage requirements, and also understand that just as a practical matter, paying a flat amount doesn't mean the person's going to work just until the job's done, period. There's a point at which they'll say, well, that's not worth my time to work 48 hours a month at minimum wage. I'm not interested in doing that. So they shouldn't try to classify someone as salaried, true salaried, without their town attorney looking at it or a tax professional. Because there are penalties, there's serious penalties. The IRS has cracked down on mislabeling of employees, whether that's in the contractor space or in the salaried space over the past 5 years. So, all right. We have a little bit of time, so I'm going to touch on some questions here, and I don't know if we'll be able to get to the harassment thing, which is fine because it's all going to be online, and you can watch the video and get the training materials from yesterday's, which will actually be a more full version than I would be able to do today, even in the best of circumstances today. Can we put a folder on the website of all the forms required for new employees? Molly, I can try. I've thought about that at different times. I'll review that and see if I can. And I'm gonna recruit Carl for that too. It's a matter of finding time to do that and checking and make sure we have everything. And also, we really want to make sure we have it all because folks rely on it when it's there. And if it's not, if it's something we didn't think of or didn't know about because of a special circumstance, that can be seen as a shortcoming on our part. So I'll see what I can do as a new hire kind of checklist or something like that. Are there rules regarding elected officials and time put into the position? I'm not sure what you mean, Jody. I'm not sure what, you'd have to give me more there. I'm not sure what the answer would be on that. Has the IRS changed the rule in election judge wages and whether or not tax need to be taken out? I don't recall that they have changed. There are a couple ways to do it. I think our approach at MAT has been to just pay them as employees, like you do any employee withhold, and report that way. It still uses a W-2, I believe. Either way, it's an election judge doesn't get a 1099. They're not a contractor. They are an employee, regardless of the amount they're paid. It's just a matter of whether you withhold. Why withhold taxes for $45? As a practical matter, it's just because getting into the different ways to do it causes confusion and inevitably leads to problems. Whereas if you just withhold, you're not going to run into a problem. It's a safety issue. Is there any harm in doing these for everyone? No harm in doing these forms for everyone. They could be done for everyone. That's no problem. Contractor for a road grader man is salaried. Well, if he's a true contractor, he's not your employee. But if you're saying he's salaried, you're kind of saying he's an employee. So I think the supervisors or somebody needs to contact us or the town attorney, and there would be a discussion of what do you actually have. It could be a contractor with an hourly rate, perhaps, or a contract with a minimum payment, but that wouldn't be a salary. So we do need to review some of that. Okay, so looking through these again. Our accountant said that election judge Wade is not taxed. No, sorry, election judge wages are taxed. It's either they have to report it and pay the tax or the township has to remit the tax, but they're not tax-free. A minimum wage for employee definition for payroll. Minimum wage, I forget what it is. I think it's 7 something an hour. It's the federal, I believe, right now. I'm going to stop my screen share here. I can open up a browser window. Federal minimum wage right now. Oh, state is listed as 10 and in 2021, there's a modifier to 1008. Federal looks like federal is lower now, so Minnesota must have changed it. I don't remember that. The federal minimum wage is $7.25 an hour. It appears that the state has upped that, so you'd have to give the higher of the two. Is there state law how much to pay election judges? No. The board can set what they pay. Again, it would still have to be at least the minimum wage. Okay. Our treasurer and clerk are appointed. We are paid a meeting rate. Do we need to change? As long as the meeting rate is at least a minimum wage for the hours worked, it's fine. Many townships pay clerk and treasurer meeting fee, same thing. Okay, so if it's at least minimum wage, you can do a flat fee, but they have to understand it's not salary. So if there's too many hours, that would be a problem in the pay aspect because now you're not paying a minimum wage. Lots of questions on election judge issues. I don't think we're going to resolve it today. We can look at the resource that we have. Somebody just posted EL 6000. My memory of this is that it was various ways to do this, and this is back to Lucinda's time. But the way she was recommending and that the trainers were recommending was just do the W-2, take out the taxes, just do one method without any without any other second method to confuse people. Otherwise, take a look at EL 6000 and send us your question. I don't believe there's any wage that's not taxed. We could go back and look at that, but I just don't think that's the case. It could be that you don't have to give them a W-2, but it doesn't mean that you can't give them a W-2 or that wages below that aren't taxed. So we can look at it despite anybody's disagreement. This is my memory of this thing. So I'm done with election judge questions, folks. If there's other questions, we can field them. I've got to thank you. Is there any others? There was one that I think I put on hold. 2 new duties. Okay. That was the one I put on hold. Okay. So there's not a simple list of statutory duties. In general, your clerk is your chief election official and has duties related to that statutory duties. And then they have statutory duties related to data retention and data management. When we look at duties of the treasurer, it's even more limited. They're, again, working with finances. There's two statutes in Chapter 367 that are a very basic description of the clerk and treasurer duties. The issue is that for the clerk, there's a ton of duties in chapters 200 through like 213, which are the election management. Not every chapter has a duty for the clerk. It's just that those are the election statutes, and they're not, particular necessarily to townships, at least not all of them. So clerks have a lot to do with that. And for clerks, that's why we recommend you use the calendar, whether it's our MAT calendar or the Secretary of State's election judge calendar. And the duties and deadlines are put on there, and they're especially the Secretary of State's calendar. That's pretty robust. So there's a lot there that you can see on something like that. Lori just mentioned we'll do election training this summer. Your county for election judges is supposed to put on training for election judges, and we don't typically do that because they have to do it themselves. So when I think of the action words for clerk or treasurer, it's receive, provide, accept, post, in some cases, publish. It's kind of those action words, whereas with your supervisors, it's consider, decide, discuss, conclude. So it's largely decision-making kind of function. That's not to say that clerk and treasurer don't make any decisions. It's just that more of that is done by the supervisors than it would be the clerk and treasurer. So those are the base statutory duties. Anything that's not given to a clerk or treasurer explicitly or somehow implied in one of their statutes, we would say, okay, that's not their issue then. If it's not given to them in statute and it's something extra, it's really something that resides with the supervisors. So to give you an example, meetings have to be posted, as you already know, special meetings in particular. But the statute doesn't say who has to post them. I think many clerks just do that as part of their work, and they help out, and that's what they're available to do. So they take on that duty, but nothing says it's a statutory duty for them. So the supervisors could do it. The clerk could do it. I could go post it if it were convenient. It's probably not convenient though. Anybody can post a meeting. An upset citizen could go try and post a meeting. What happens though is the supervisors actually have to show up to make their quorum, and then you get your meeting if it's posted properly. Okay, so in that case, the clerk or who's ever doing the posting is taking on something that's really a supervisor job at base. Okay, and they're doing it for them, and that's all okay. If they come to an agreement and it's okay to do that, no problem. Another one that comes up is who gets the mail. We don't know why this is a fight about anybody. Who gets the mail? Well, nothing says the clerk gets the mail. So it could be anyone. It could be that the supervisors decide, well, we're going to, so-and-so is going to receive the mail. Supervisor A is going to get the mail, bring it to the meeting, and we're going to sort it there. Or it could be let the clerk or treasurer get the mail. It doesn't matter as long as you guys come to some conclusion about this. Okay, something that works for you. But remember, clerks and treasurers, if we can't find a statute explicitly or something implied for you, it's not actually your job and you're doing extra. And I've said to supervisors in their room, don't overlook how much extra your clerks and your treasurers are doing. Don't overlook that other units of government employ people part-time and full-time to do all these things that town officers are doing at what might be no extra cost. Okay, and that's not to say supervisors don't do that stuff too. There's many of them that do. My concern is often guarding against the clerk and the treasurer being perceived as a secretary, as just an administrative assistant to the board, which is not their true role. You're officers in your own right, even if you're appointed and you have things you have to do. So that's we could do specifics if you have specifics, call us and we'll talk about your town specific issue on distinctions. Carl has done a presentation on those different roles. I don't recall if that one's on Seminar Web or not. Okay. Whose responsibility are W-2s? I guess that's the same kind of thing. I'd argue it's supervisors. So they better work with you if they want you to do them, because record keeping is not producing. That's different. Okay. Minutes. Nothing says the clerk has to take the minutes. It's common. It's okay. But if you're being harassed about your minutes, you could say, I'm not doing that right now. If you're an elected official, if you're appointed, they have more administrative control over your duties. So one meeting a month, I would say, yeah, at least one meeting a month, and separate your payroll from that meeting. And what you get at the end for supervisors, they should get a report of what was paid and they can review it. And if there's problems, they make changes, but it's forward looking. Okay, it's not backward looking. Okay. When asked to run for the clerk's position, I was told it's only writing an agenda and minutes. They lied to you, Brenda. I'm so sorry. Only 1 hour a month. It'll be nothing, right? I'm sorry about that, but I'm sure you're doing a great job and taking the time that's necessary to do it. And I hope we're making it easier. And I will talk to Lori and I will get something, whether it's a training on the election judge thing, because obviously there's a need and there's disagreement. Okay. So we will respond to that too. And the election forms, we'll try to put together something there too. Let's see. Okay, 1 month. Would you please share a link to the seminar on official roles? If I can find it, I don't know that I can. If Lori or Kristen could look, if Seminar Web has it, you could just do a link to Seminar Web. Okay, if not, I'll consider having Carl do that one and put it on Seminar Web too. Considering that treasurer does insurance claims for fire bills that residents serve. So a treasurer doesn't have to do the insurance claims or collections and stuff. That would be beyond the treasurer's statutory roles, but you could agree to do it. Be aware of the time that's going to be invested in it. Insurance management is not done like over 5 minutes. Our new employee that you see here, Heather Tidmore, is employed to do that work. It's a real job. It can be a big job depending on how much you guys have for that. So, what to put under deductions? Well, it's your state and federal tax deductions. If you know of any other withholdings that are going to be made, you'd put those in. Like if there's garnishments or if they want anything sent to any other tax deducted kind of benefit that they can use, para, something like that. Those are the things that you're going to see in there. I'll see if we can find some common ones and maybe we can provide some help with that. I don't know if we can. So wage theft form. Let's see, can I copy paste? Oh, copy paste the same one. There's the wage theft form. And that puts us at 11. So I believe, Kristen, what's up next? Or is that it?